We've all heard about these ICE detentions at immigration court hearings, and I want to explain a little bit about what's going on and why it's so important that we move for an independent immigration court under the judiciary. Here's what's happening. ICE is prosecuting people for deportation. Technically, most people have the right to defend their deportation in front of an immigration judge, except those that say have prior orders of removal, in which case ICE can detain and deport them, and those which are subject to expedited removal. And that is a key component here. Individuals who have been in the U.S. for less than 2 years and who entered without inspection or entered with some humanitarian parole in some cases are subject to expedited removal. So someone may have entered the U.S. in the last 2 years seeking asylum. They entered without inspection but sought asylum. They are placed in deportation proceedings to present their asylum case. Now, if they've been here for less than 2 years, they can say, actually, we're not going to prosecute you for deportation. We're just going to terminate those proceedings and deport you under expedited removal. Expedited removal means that we do not have to give you the opportunity to fight your case in front of a judge. Okay, so these are the people that they are targeting in their immigration court dates who are showing up in good faith. And they're saying, oh, actually, we don't have to give you this opportunity in front of a judge because you've been here less than 2 years. And so we're just going to terminate these removal proceedings, detain you almost as if you had just been detained at the border, and expeditiously deport you. Now, ICE prosecutors, right, the government's attorneys are deciding to terminate or dismiss cases, much like a criminal prosecutor can choose to dismiss cases. So you have a crime that someone is accused of. The prosecutor looks at the evidence, looks at the probability of success, and can choose to dismiss the charges. That's exactly what's happening in these cases, except for not because they think there's a valid defense, but because they know that they can just be deported without having an immigration judge weigh in. And you might say, well, why are immigration judges allowing this? Ultimately, they're the superior authority. They can say, no, I'm not going to allow you to dismiss the case. We're going to hear this on the merits of the case and allow them to present their asylum, as a defense. Well, there's a lot of discretion, prosecutorial discretion, in terms of whether or not, they have to prosecute. And that is the ICE's attorney's decision whether or not to prosecute. And so a judge can't force them to prosecute. However, a tactic for immigration attorneys has been, well, sure, you can orally move to dismiss, but we want you to make it in writing pursuant to the practice manual, make it in writing, and give us time to respond in writing. At a minimum, to prolong and give us time to reconvene and see what's going on if there's another defense or strategy. However, and judges were allowing this. They were allowing attorneys to make these motions so that they couldn't terminate on the spot and be detained by ICE on the spot. However, immigration judges and ICE attorneys work for the same boss. They all work under the Department of Justice. And now immigration judges are being told not to give people time to respond, not to require the government to put their motions in writing, and that oral motions are sufficient and should be granted on the spot. So this is not a neutral arbitrator here, right? This is a judge and a prosecutor working under the same boss, unlike in a criminal court where a judge works for the county, the state, and under the judicial branch. That is not how our immigration system is set up, and this is why immigration reform is so necessary.